Good morning, everyone.
Good morning.
Welcome to the Future of Elder Wellbeing Summit. I'm Nicole Stevens. If you look in your program brochure, it'll tell you that I am the director of the Probate Division and the Register of Wills. It's my pleasure to be here with you today and be your moderator for this morning's keynote address. Before we begin, I'd like to share a few quick housekeeping notes. So if you have any questions throughout the day, please look for our volunteers. They'll be wearing yellow badges and they are there to help you. They can answer any questions, tell you where the bathrooms are, etc. Restrooms are located on both the first and second floors of the Kellogg Conference Center. All plenary sessions and the afternoon panel will be held right here in the auditorium, and our breakout session will take place in both the auditorium as well as upstairs in room 6ABC. Please review your agenda to determine which session you wish to attend and its location. We also have a fantastic group of exhibitors right outside these doors in the area located between the auditorium and the outdoor patio. Please take time to visit them, look at their materials, and learn about their work. For those seeking social work continuing education credit, please remember to sign in at the registration table and each breakout session you attend. Finally, when you receive your CEU information, you must complete the summit evaluation and return it to the registration table at the end of the day. You'll then be given a flyer with instructions on how to purchase your certificate from the National Association of Social Workers. The cost is $12 with the payment, and the payment goes directly to the National Association of Social Workers. So that is the housekeeping. I believe we also are giving credit to fiduciary panelists as well. I don't know if there's material out there for you, but I will check on that afterwards. So you also can get credit for attending the summit today. So now it is my great honor to introduce our distinguished keynote speaker, who will be appearing virtually, Professor Nina Kohn. Professor Kohn is a renowned expert and a leading voice in the field of elder law and civil rights. As a distinguished professor of law at Syracuse University and a scholar at Yale Law School's Solomon Center, her work is at the forefront of the very issues we're here to discuss today. From innovation approaches to guardianship reform to the fundamental rights of older adults and those with cognitive capacity challenges. She has served as the reporter for the key Uniform Law Commission Acts and has a deep understanding of the legal, ethical, and practical challenges we face in our work. Her insights into emerging best practices are essential for all of us who seek to improve the lives of vulnerable adults. Please review the speaker bio section for more background information and her very extensive bio. Please join me in giving a very warm welcome, virtual, to Professor Nina Kohn.
Well, thank you so much for that kind introduction. It's a real pleasure to be here with you today. I am going to be talking a little bit about some of the key challenges and opportunities facing older adults today. And just give me a minute here and I will share my screen. Okay. Just a quick note, everything I'm saying here today represents my own views and does not necessarily represent the views of the organizations sponsoring this event or those funding them. So as we think about the future of elder well-being, there are so many opportunities and challenges facing us as a society as we see a growing elder population. But today I'm going to focus just on three big questions that we're confronting. And because we're being hosted by the DC court system, I thought I'd focus on three big questions that interact with our justice system. First, how can we address and remedy elder abuse? Second, how can we ensure that guardianship is only used as a last resort? And third, how can we improve guardianship systems for all involved? So let's tackle each one. We'll start with the first one. So if we think about elder abuse in this country, I don't think I have to tell anybody in this room that it is a significant problem. We know that at least 10% of Americans age 65 plus experience some form of abuse or neglect each year. Best evidence is suggesting that about 7% of people 60 plus in the US experience financial exploitation each year. And this is a costly problem. AARP has estimated that financial exploitation alone costs older adults in the United States about $28 billion each year. And I think it's important to note as we think about this that elder exploitation doesn't hit all populations equally. And that when we see differential impacts on who's hit by financial exploitation, it can contribute to wealth inequality in our country. So for example, prevalence rates for financial exploitation appear to be a bit higher for Black older adults than for white older adults. Certainly there's some demographic factors that contribute to that, but it also reflects the fact that we're seeing some scammers actively targeting Black communities for exploitation. Okay, so when we think about the problem that is financial abuse in America, we know that actually the bulk of that abuse happens from people who the older adult knows. But a growing concern are stranger perpetrated scams, so stranger perpetrated financial exploitation. And part of the concern there is that these scams are growing more and more sophisticated. So we're talking a whole range of scams, right? We're talking the scams that involve tech support. You know, your computer is infected and you need to act now. And we're talking about scams where there's impersonators, such as impersonating the federal government. And we're also talking often about relationship scams, where the scammer builds a relationship with the individual and then begins asking for money. And part of the challenge we face as a nation is that scammers are increasingly becoming sophisticated and using AI to their advantage, making it very difficult for individuals to figure out, is this real or is this fake? Right? When the scammer can sound like your loved one using AI, how do you know? So we can think about the various ways we could address this as a country. And one of our dominant responses right now is to require elder abuse to be reported to the state and to encourage elder abuse to be reported, even if there isn't a mandate. But every state and the district, of course, require at least certain categories of people to report elder abuse. The question is, how much do we get as a result of that intervention? And here's the concern. If we actually look at the research, while states have made mandatory reporting a go-to response, it's not really clear that that's helping older adults. There's some evidence that when you put in place a mandatory reporting requirement, you get more reports, you get more investigations, but those effects don't necessarily last, and there's not evidence that it actually leads to more substantiated cases of abuse. And as colleagues and I wrote in a recent article that we put out this spring, there's a real lack of evidence that mandated reporting actually ultimately improves outcomes for older adults. Complicating matters as well is the fact that often the interventions we're offering to older adults, especially the involuntary ones, aren't necessarily aligned with elders' preferences and values. So I think we need to be talking about this and thinking about what are some of the emerging approaches we could use to better address elder abuse in a way that meets people's goals. So for example, let me just lay out what I think are sort of three promising areas of research or innovation in this space. I think one thing that's really promising in this space is that we're seeing some real scientific advances. So scientists are learning that financial decision-making abilities decline well before other types of decision-making abilities, and that susceptibility to scams and exploitation actually kicks in years before typically you have a dementia diagnosis. At the same time as we're getting that sort of new scientific understanding, we're also seeing financial institutions developing the technology tools to detect patterns of financial conduct that are consistent with cognitive decline and that are also consistent with potential exploitation. And if we can leverage these tools, albeit in a way that is hopefully not too heavy-handed or unduly paternalistic, I think it could be a game changer to really help protect people before they end up losing their life savings. Another promising development in this space, I think, is the RISE collaborative model. Now, I wish I were in the room so I could ask how many of you are familiar with this, but maybe we'll hear some of that in Q&A. But this is a restorative justice model approach to responding to elder abuse that's being pioneered in a couple communities. And what it does is it pairs the older adult who has experienced mistreatment with an advocate. Now, that advocate is a professional based in a non-governmental organization, and the advocate's job is to help the older adult embrace a desire to change their circumstances and to identify what goals they want to achieve. And should the older adult wish, the advocate can also facilitate restorative justice practices, for example, to try to repair the relationship between the older adult and the person who has harmed them, provide an opportunity for the harmer to make amends and the like, and ideally to build a supportive team around the older adult going forward. A third promising approach I want to note is Coach, which is a pilot project out of California. And what it did is it provided family caregivers with telephone coaching support. Now, they just did a very, very small trial, but in that small pilot project, they found remarkably promising results, suggesting that this very low-cost intervention of providing some limited coaching by telephone to caregivers could actually go a long way to preventing caregiver abuse of older adults. So I think there's some exciting things we can be looking at in this space. Let me turn to the next big question I wanted to talk about today, and that is how can we ensure that the guardianship system is only used as a last resort? And I think it's important to think about why at the outset it's important to make sure that guardianship is only used as a last resort. Now, I suspect I don't have to tell anyone here today that there are few judicial proceedings that are more impactful, right, than a guardianship proceeding. We know that guardianship can provide very valuable protection and assistance to those who cannot care for themselves or make decisions for themselves, right? So think about the individual who has advanced illness and a chronic health condition, but also has dementia, which prevents them from understanding the nature and consequences of their health condition, even with help. And they never appointed an agent to make decisions for them. The best outcome in that type of situation may well be for a court to appoint a guardian to make decisions for the individual. And yet at the same time, we have this paradox, which is that although guardianship can be very protective and valuable in some cases, we know it can also lead to new forms of mistreatment. So unfortunately, there are unscrupulous guardians who exploit the people they are supposed to protect. That may be very deliberate, or it may be something less deliberate, like charging unreasonable fees without court oversight. We also know that guardianship can isolate older adults. We know that guardians routinely consent to institutionalization. We know that in most states, a guardian can restrict a person's access to their family and friends with virtually no limits. And even if there's no bad behavior involved, imposition of a guardianship in and of itself can create stigma for the individual. It can be traumatic, right? Because individuals are commonly losing the right to make nearly all decisions for themselves. So it's critically important, given all this, that guardianship only be used as a last resort, right? That guardianship only be used where a person or their property is at substantial risk and other less restrictive means can't adequately address that risk. So what can we do to make sure that guardianship is in fact only used as a last resort? And I think one of the most important things we can do is to recognize the array of less restrictive alternatives to guardianship that exist. So let's walk through what some of those are. First, we can think about what are some court orders that can be put in place that are less restrictive than, say, a plenary guardianship, or plenary just meaning a full guardianship, one that removes all rights that can be removed under state law. Well, one alternative is a limited guardianship or conservatorship. Right? If you think about it, virtually every guardianship should be a limited guardianship. Why is that? Well, because even people with very significant disabilities can probably make decisions about some things, right? What to wear, maybe what to eat, whether they want to see their friends, whether they want to go to church, right? Even if you have a very significant disability, most likely there are certain things that you can make an informed choice about, right? So we should be expecting that virtually every guardianship or conservatorship is limited. Alas, the reality at the national level is that the vast majority of appointments are plenary. So limited appointments is one option. Another thing we can think about are temporary orders, such as temporary restraining orders. If we have an individual who is being exploited by another, can we put in place a TRO to remove the risk without stripping the individual of their rights, right? The concern is that victimization leads you to lose your rights. It's a bit ironic. So how can we use temporary orders? Another thing we can think about is using orders for protective arrangements or a single transaction authorization in lieu of guardianship or conservatorship. Right? So sometimes we are faced with a situation where an individual has done some planning, but perhaps has not authorized an agent for the particular decision that needs to be made. Do we need to put in place a guardianship? Perhaps not. Perhaps we can just have a court authorize the particular thing that needs to be done. Now, in DC, I believe you already allow this for financial orders, right? Which is terrific. But you can also think about how you might reform your law to broaden the array of protective orders courts can do instead of guardianship. Saves the court some resources ultimately as well later down the road in terms of monitoring. Okay, in addition to the court alternatives, we can think about what are some other ways we can meet people's needs short of guardianship altogether. And I think we need to remember that sometimes we can look for a federal agency to appoint somebody to make the type of decisions that need to be made in a much more limited way. So let's imagine we have an individual whose primary or only source of income is Social Security. They're having trouble managing their money. Right? What's a less restrictive alternative to guardianship? Well, a less restrictive alternative to guardianship in that case might be appointing a Social Security representative payee to manage those Social Security funds. Similarly, imagine we have somebody whose primary form of income is Veterans Administration benefits. Putting in place a VA fiduciary may be a less restrictive alternative to guardianship. But then there's the things that people can do themselves. And one of the great things when we think about the things that people can put in place for themselves is that the things you can put in place for yourself, you can also remove for yourself. So even people with very significant cognitive disabilities may have sufficient capacity to appoint an agent under a power of attorney, an agent either for healthcare or an agent for finances or both, to make decisions for them. Right? You don't necessarily need to have capacity to make those decisions yourself, to understand, here's the person I would like to make those decisions, here's the type of decisions I want them to make, to have capacity to make that appointment. Similarly, trust can be a terrific alternative to guardianship. If you can in advance have your money and resources managed by a trust, then even if you lose capacity to manage those resources yourself, the trustee is in a position to do that. And another alternative we need to be thinking about, I think very seriously when we're thinking about things that individuals can do, is supported decision making. Right? So an individual may have difficulty making a decision in a totally autonomous way, but it may be that if they have somebody who can help them obtain information, think through information, and communicate decisions, that they're able to make decisions for themselves. And so supported decision making, which is a process by which an individual receives help in making decisions, and again, that may be in obtaining information, that may be in processing information, weighing options, communicating decisions once made. It may be that an individual can use supported decision making to make decisions, even if they wouldn't be able to make those decisions on their own. Most of us, frankly, use a little help, right, when we're making big decisions about our lives, and people with disabilities are no different in that way. Okay, so a lot of options out there that we can be thinking about to ensure that guardianship is in fact only used as a last resort. And one thing I would encourage those of you in the room to do is to play a role in educating others about less restrictive alternatives, because unfortunately, many people who work with older adults, and that includes us lawyers, really aren't fully aware of the array of options. Okay, the last big question I want to make sure that we talk about together, and I'm going to take a little bit more time on this one, is how do we ensure that guardianship systems are excellent? What can we do to improve the experience of guardianship? Now, I'm going to speak sort of at the national level. I realize I'm not on the ground in DC, so I'm looking forward to hearing a bit perhaps about what you are already doing. So as I think about improving guardianship systems, I'm going to break this down by stage of guardianship. I'm going to start by looking at problems that occur before a petition is filed and what courts can do at that stage. Then we're going to look at some of the problems in the adjudicatory process and some of the best practices to address them. And then we're going to look at processes immediately following appointment. And finally, we'll talk about problems and opportunities related to ongoing monitoring of guardianship. So I'll break it down by stage. So let's think about some of the challenges we see before a petition for guardianship is ever even filed. One challenge we see is that petitions are sometimes filed when guardianship is simply not the appropriate response. Another thing we see is that petitioners have a tendency to request broad guardianships and often unnecessarily broad guardianships. Well, what can we do about this? Right? One thing we can do is to set the expectation that less restrictive alternatives will be tried first. Now, how do you actually operationalize that? I think one way to operationalize that is to think about what are the forms that the court system is asking people to use to request a guardianship. The courts can provide a petition form that actively encourages less restrictive alternatives. So for example, in the Uniform Act, the model form we put in there asks people if they've tried less restrictive alternatives. If not, why not? If they have, why have those not worked? Right? That prompts the petitioner to think about these alternatives, and it also provides the court with some really valuable information as they're trying to decide, would a less restrictive alternative meet the person's needs? There's also, I think, a really terrific opportunity to leverage existing systems to educate would-be petitioners about some of the alternatives. So let me give you an example of one probate court's website, just to show you how this works, right? Courts have websites. You don't have to build anything particularly new to do this. But you see right up front what this probate court has done is tell petitioners about alternatives, right? So before you're ever filing that petition, you're given a useful, layperson-friendly rundown about what some of the alternatives are using state-specific language. And what I like about this sort of investment is not only does it really help the petitioner, right, but ultimately this type of thing I think can save a court system some substantial resources. Right? It may result in fewer petitions for courts to deal with. And second, it may result in a smaller proportion of petitions being granted because if you combine this with a requirement to say whether you've tried less restrictive alternatives, and if not, why not, it may make it clearer for the court when a guardianship is not appropriate, or at least when it's premature to be appointing a guardian. Okay, so let's talk a little bit about some of the challenges we see at the adjudication stage. And I think one challenge facing many courts is that they're not necessarily getting the full information they need to make informed decisions. We see at a national level courts relying very extensively on allegations in the petition without independent evaluation. We see at a national level many respondents lacking counsel, and sometimes that's lacking counsel full stop, and sometimes that is that the person has counsel, but the counsel is playing a role more of a guardian ad litem. They're advocating for what they see as the person's wishes, what they see as the person's interest, and not what the person actually wants. Right? That's not really having an attorney. We also see at a national level that guardianships are often granted without the judge actually hearing directly from the respondent. And additionally, unfortunately, many judges at the national level lack the expertise and resources to identify less restrictive alternatives to plenary guardianship. Okay, so that begs the question, what can we do about all this? So let me talk you through some ideas. So when we think about the first problem I identified, courts relying on information and petition without independent evaluation, a couple things that court systems can do in this space. One is to appoint a court visitor to make an in-person visit. One is to appoint an independent professional evaluator. So you're hearing from somebody who has training and expertise in the disability alleged. And then I think one of the most important things for court systems to do here is to hear directly from the respondent. So unfortunately, in many states, what you can do is waive the person's presence for good cause, right? And the idea is, well, if the visitor said that person can't really contribute much, we don't have to hear from them. Well, that's a decision for the judge. Right? That's what the judge should be deciding. So we need to make it clear that absent truly compelling circumstances, the judge should be hearing directly from the respondent. When we think about the lack of counsel issue, a couple things we can do in this space. First, ensure that respondents have counsel. Second, make it very clear that the job of counsel is to represent the respondent's wishes. And one opportunity there is to go back in and look at your roles of professional responsibility. Maryland just revised its rules, 1.14, to provide better guidance to attorneys working in this space, because sometimes attorneys are legitimately confused. And the good news now is that the ABA is tackling this issue as well. And so I predict that this time next year, we will have a revised ABA rule that you can look to that really, I think, will help attorneys in this space understand their obligations. But let me share with you for a moment one state's innovations in this space, which I think are really exciting. And that's what's happened in Nevada. Now, Nevada, if you read the New Yorker article and others, had a pretty big guardianship scandal. Well, how did they respond? One way they responded was by enacting a statute granting guardianship respondents appointed legal aid counsel. And so what they did is they said, well, look, unless respondents have retained their own counsel, they're going to get a specialized attorney from legal aid to provide their defense. And that reform has had real impact. It's substantially reduced the number of guardianships granted. It's resulted in unnecessary ones being terminated. And it's protected substantial sums from exploitative guardians. So I think it's a great example of how some upfront investment in due process can actually reduce the longer term costs of ongoing monitoring of unnecessary guardianships. Okay, other adjudication challenges. When we're thinking about granting guardianships without hearing from the individual, this is a good time to go into your law and see, well, what are the exceptions that we allow? Do we allow a good cause exception? Should we be allowing a good cause exception? And perhaps should we be narrowing that language to make sure that the individual does have their day in court? And finally, when we think about the lack of judicial education in this space, I definitely feel for judges. These are often big churn areas. People are being churned through different courts. We need training to be frequent and routine. So kudos DC court system for today. And the good news is there's some great resources out there put together by other folks as well. The National Institute for Justice, the National Center for State Courts have some useful training materials as well. Okay, let's turn to that third stage of guardianship. We've put in place a guardian. Now the challenge is around monitoring. And I think we have a couple key challenges here. Unfortunately, at the national level, we know that court oversight of guardians is inadequate, at least oftentimes. Let me give you one data point. Texas. Now, full disclosure, I am incredibly impressed at Texas for being willing to pull back the curtain on the challenges its courts are facing. So what Texas did is it studied its guardianship system. And you know what it discovered? It discovered that once guardians were appointed, its courts often had no idea what had happened. In fact, it found that 40% of cases lacked current reports, and thus the court didn't know were the person's needs being met, was the guardian performing their duties. Courts in many cases didn't even know if the person was alive. The state found over 5,000 cases in which the individual subject to guardianship had died without the guardian telling the court. Part of the complication here is that lay people often don't have a viable route for getting court attention when they spot problems, so they're not in a position to help the court to get ahead of these issues. The good news is I think there's some exciting things that can be done in this space. Let me share three things we see courts doing. One is we have some courts using volunteer visitors to visit the person subject to guardianship to check in on them. Can be a really great thing to do. It's sometimes hard to maintain because the visitors themselves tend to be elderly, and you have to be constantly bringing new people into that program. But it's an exciting option. Another thing we see some states doing is creating layperson-friendly complaint processes, making it easy for lay people to notify courts of problems they see. And then another thing we see courts doing is leveraging technology. So let me tell you a little bit more about those two for a sec. When we think about leveraging technology, Minnesota was really a leader in this regard. Other states are beginning to follow the lead. But just to give you sort of a window into what this looks like, in Minnesota, they've created a guardianship tracking system that helps guardians keep their obligations to the court by sending out reminders of when reports are due. And that allows the courts not simply to see what's filed, right, but also to have sort of an automatic tickler about what's missing. That is, when reports have not been filed. And it also allows for important sharing among the courts in the state. For example, if a guardian is removed for good cause, the system can alert judges in other counties where that guardian has been appointed, and that gives them the heads up to look into whether, gosh, may there be similar problems that are happening in cases in which I've appointed that guardian in my county, because we know that often one guardian will have dozens of appointments. So this kind of monitoring isn't exactly rocket scientist, right? Like, I think about my kid's orthodontist, right? I get an automatic message when I have an appointment for them so that I don't forget. And if I come in with one kid, they have a tickler to remind me I owe money on the other kid and they can collect it, right? This sort of system, though, can be transformative, I think, in the context of guardianship monitoring. So Minnesota's an example. Pennsylvania has a pretty robust system as well, and there's some others to look at. In terms of layperson-friendly processes, again, this is a place where you can take advantage of a court website, but you don't need to. Here's a form that's used in one state, in Washington, which has adopted the Uniform Act. What a form like this does is it makes it possible for people who aren't lawyers, who aren't really familiar with the system, to let the court know if they see a problem. And the reality is that the likely good Samaritans here, right, the people who might notice that something's going wrong, right, the CNA in the individual's nursing home, or the niece that comes into town for a visit, or the mailman who notices a problem, they're not going to hire an attorney to make a motion or follow a formal process. So if we want to leverage their knowledge, we have to make it really easy for them to let a court know if they think something's going wrong. And courts then need to have a system for receiving informal reports from lay people, including, frankly, the individual subject to guardianship. And this can be a way, I think, of leveraging the community to be an extra set of eyes and ears for the court. So I've been talking about a lot of things that can be done to improve guardianship systems. And I've been talking about them up to this point as if they're all sort of individual items. But I think it's important to note that from a law reform perspective, there's kind of a one-stop shop for a lot of the things I'm recommending. And that's the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. I'm sorry, I know it's a mouthful. What this is a model act for states and the district. It was adopted in 2017 by the Uniform Law Commission. The Uniform Law Commission is an organization that was founded in the late 1800s. And what they do is they try to create sort of template legislation for states on issues that are technically complex or where there would be helpful to have uniform approaches so that you have sort of best practice legislation. And the act has ultimately been adopted so far in 3 states. You see them in blue, but it's also been recommended by the U.S. Special Senate Committee on Aging, the American Bar Association, the Fourth National Guardianship, the ARC, AARP, I could go on. And so many of the legal reforms I'm talking about can be found right in that act. Let me just, before I wrap up here, just give you a brief sampling of some of the types of key provisions that are in that act that might be sort of little nuggets that you could bring to DC even if you don't adopt the full act. It includes a limited basis for appointing a guardian, really making it clear. Court, you can't appoint if a less restrictive alternative would meet the person's needs. It authorizes a broad array of limited orders short of guardianship to try to expand the range of less restrictive alternatives out there. It includes the expanded requirements for petitions that I mentioned. It requires guardianship plans so that the court can evaluate, hey, what does the person say they're going to do? What did they actually do? Let's think about what are we actually putting in place for the individual. It creates an informal grievance procedure like I just discussed. It tries to make things a little easier for guardians by creating some really clear decision-making standards. And it also has a series of provisions that facilitate restoration of rights. So if anyone's interested in that, happy to talk more offline about it. So those are the 3 big questions I wanted to talk with you about today. How do we address elder abuse? How do we make guardianship a last resort? And what can we do to improve guardianship systems? Of course, these are just 3 of the many big questions we have as we see this growing aging population. But I look forward to talking with you more about those 3 questions or other ones that you may be confronting. So thank you so much for having me here today. What I thought I would do now is open it up for any discussion.
Thank you, Professor Kohn. Does anybody have any questions? I can start it off. So, looking at the audience of professionals and community members here today, what's the one key takeaway that you hope everybody leaves with about their role in challenging current practices and adopting new approaches in their work with older adults? And I'll just say that a lot of members in our audience are social workers and attorneys who work with our incapacitated individuals in the probate division. So,
I think my takeaway would be, there's so many, but one thing is I think we need to be asking both about what people can do and not just what they can't do. I think sometimes when we're thinking and we're seeing problems, we're saying, well, the person can't do this, they can't do that, they can't do the other thing. But it's also really important to think about what is it that the person can do and make sure that we are not removing their right to do the things they can do. So how do we capitalize on the strengths, not simply fill the gaps, right? Capitalizing on the strengths is one way, though, to fill the gaps.
okay. Are there any other questions in the audience? No, you have one.
I don't really have a question. I just had a couple of statements. I'm the former president of the National Guardianship Association as well as the Center for Guardianship Certification. And I'm also from Minnesota, which you mentioned, with our MMG and MMC. I also want to mention that we are petition for guardianship in Minnesota is now 25 pages long. It goes through and you have to explain all of the different types of alternatives that you have attempted and why they have not been successful. And so that's something you could look at to adopt in other places. And I'm also going to put on my certification hat and recommend certification for people that so we recognize the standards of practice and ethical principles that a good guardian should be using when they're practicing. So I just wanted to make those couple of statements. Thank you.
Thank you.
And I'll just add that those guardianship standards are a terrific resource for people.
Could you address, in terms of like when there's a petition to go in for guardianship, in terms of what entails a capacity assessment, what kinds of things should be included, how extensive it should be? Thank you.
Well, in my ideal world, nobody would have a guardian appointed without a full professional evaluation by somebody with training in evaluating people with that disability, whether that be a geriatric social worker or a geriatric a psychiatrist or the like. But I think when you're thinking about it, it's really important to break it down by domain. So as opposed to the question, do you have capacity, breaking it down by types of decisions, because people may be able to understand some types of decisions and not others. The University of Southern California just finished up a project creating a bench card for judges that sort of lays out some of these issues in a domain-specific way. I'm not a capacity evaluator, so I feel a little bit like I'm speaking out of turn to say exactly what a capacity evaluation should have. But I think if we overlay that with the legal criteria, it's absolutely essential that we're not asking sort of the blanket question, does this person have capacity? But looking at particular domains, what are the person's limitations in a domain, plus what are their abilities in that domain? And one thing we should be asking of capacity evaluators is to identify abilities and not simply limitations.
Great. Anybody else? No? Okay. Then I can ask my question. Okay. So, as a court administrator, we're very much in the middle of when these cases come into the probate division. I didn't see this in your presentation, so I'm gonna, or I might have missed it. So, excuse me if I'm repeating anything that you've already mentioned. What are your thoughts on mediation regarding incapacity? We here in the District of Columbia, we actually have a mediation program for incapacitated individuals, but we hardly use it. They hardly, we usually find that it's either the hospitals or really kind of against the family, and the hospitals just want one thing and the family wants something else. And it's just not mediation capable, right? So what are your thoughts on mediation, and where do you think it fits in this area of law?
That's such a great question. I'm a big fan of mediation, having trained as a mediator at one point. But, I think the question is, what are you mediating? Why are you mediating? And what is the impact of the mediation? Which is, I guess, an unfair way to talk about this. But I think, sometimes what precipitates a guardianship petition is that there is real confusion in the family as to what to do for the individual. Who's going to do what? Why? What does the person want? And bringing people together with a trained facilitator, right, a mediator, can be incredibly helpful to identify ways to meet the needs without guardianship. So I think it can be a terrific resource. My concern, however, is that sometimes that mediation can feel like the older adults being ganged up on, right?
Yeah.
And ultimately, unless there's a finding that the individual lacks capacity to make decisions for themselves, they get to make decisions for themselves. So it's sort of an odd position somewhat to be in, to ask an older adult to join a mediation about their own life and to suggest that they then have to perhaps accept the collective judgment about what is a personal decision. So I think it's really important that if you are mediating these cases, it be separate from the court process enough so that there isn't an element of coercion, or at least not excessive coercion, where the person feels, well, look, if I don't agree to this, I'm going to lose all my rights.
Right.
And so when that guardianship mediation is sort of happening in the shadow of this threat of having your rights stripped, we might be quite concerned about whether the things the older adult might agree to or the person with the disability might agree to are truly being agreed to voluntarily.
Yeah. Okay. Any other questions? A sign was held up from the back. I cannot see it. Stop. Oh, okay. Thank you. Thank you. So I'm going to wrap this up. I want to thank Professor Kohn for being here with us today, and really appreciate it. And I learned a lot. Thank you very much. And we will move on to the next session. Thank you.
Thanks for having me.
This will take a 2-minute break to set up for the next session and speaker.